Greetings and welcome to today's BDC Directors Training Series. At this time, all participants are in a listen-only mode. A question-and-answer session will follow the formal presentation. Questions can be submitted at any point by typing them into the Ask a Question box on the right side of your screen. If anyone should require operator assistance during the conference, please press star 0 on your telephone keypad. I'll now turn the conference over to Ms. Cynthia Cruz, partner at Sutherland. Thank you, Ms. Cruz. You may now begin.
Good afternoon, everyone. This is Cynthia Cruz, and I'm a partner with Eversheds Sutherland. And welcome back to our BDC Directors Training Series. I'm joined again today by Lisa Morgan and Terry Jordan. Before we get started today, just again to note the point about asking questions. If you send us questions during the webinar, we can go ahead and try and answer those at the end, but we won't be opening the lines. Today's webcast is the second in a series regarding the role of directors at BDCs. Our focus today will be on the oversight obligations of BDC directors, such as particularly regarding the third-party service providers, including the investment advisors. Like our last webcast, we'll have three main areas. The first will be the oversight, compliance, and governance obligations of BDC directors at a very high level. Painting the picture of what you're going to have to do on an ongoing basis. Secondly, we'll talk specifically about certain third-party service providers. And thirdly, because it's most important, is that we will discuss basically the investment advisor, the approval process and requirements for the board as it relates to investment advisors. So just to give you a little bit of background on BDC boards, and Terry, who will be our first speaker, will talk in more detail, is that effectively from this perspective, the 40 Act is a governance statute. It is basically put together in order to govern how effectively either the third parties or investment advisors interact with basically what the SEC believes is a pool of assets. And so that pool of assets needs to be protected from any kind of conflicts or affiliate transactions. So it basically monitors or requires certain procedures when you're digging into the assets of the fund. So if you think about it that way, almost all the provisions make a little more sense. And obviously, as a result of that the governance statute, there's some tensions around the compliance function of the board. And again, we will be talking about it as an oversight role. However, as the 40 Act has grown up over the years, there's been more and more responsibilities and requirements placed on the gatekeeper or the independent board members, because that's the mechanism in which the SEC believes that you can regulate the fund. So as a result, as the SEC looks at a variety of different requirements, you'll see that, for example, in some newly issued proposals, that the SEC is even pushing further into the world of, which may very well look a little bit more like management, and that the tension between oversight and management is continual, and you'll see that as we talk through this. And just to augment the point that I just made, there was a proposal that was put out regarding the liquidity for risk management, where the boards were actually asked or required to put in place a policy about what the risk management would be. And you could obviously argue that that's more of an investment advisor position than necessarily a board. And actually the Independent Directors Council, which is basically the board arm of the ICI, the head of that actually had a quote that I wanted to read to you, which illustrates some of that tension. It says, "If the regulators do not draw the oversight versus management line correctly, fund governance and ultimately fund shareholders could suffer," said the IDC chair, Paul Friedman, who's an independent director with the Deutsche Bank funds. He goes on to say, "Inappropriate regulatory burden could expose directors to increased liability, could reduce boards' effectiveness and congeniality, and limit the pool of qualified directors." Even incremental shifts towards management functions could lead over time to set an inappropriate board responsibility that would not be in the shareholders' best interest and would be difficult to reverse. And the point in making this or highlighting this is that even though there are a lot of functions and requirements as far as responsibilities from the 40 Act, mostly in the area of the independent board members, that you have to remember that it really still is an oversight function, and that you need to be provided the data in order to provide that oversight and ask questions about it, but you are not in any way being required to manage the fund. And I think if you remember that piece of it, it's easier to take into account some of these additional responsibilities. And I will say that a BDC board has a lot more responsibilities and a lot more materials that they have to go through than an ordinary board member would, and it's a matter of compliance with the 40 Act in order to do that. And I think that'll introduce Terry's questions and answers, and I'll turn it over to you now, Lisa.
Sure, thanks. So to follow up on that our focus here is not management, it is oversight. Terry, can you give us an overview of the oversight obligations applicable to BDC directors?
Sure, Lisa, I'd be happy to. While the majority of our presentation today is going to focus on the requirements and practical considerations regarding the board's oversight of third parties, we thought it'd be worthwhile to take a few minutes now to step back and to generally review the source of these obligations for BDC directors. As you're well aware, BDC directors, like the directors of any corporation or partnership, are responsible for the oversight and management and direction of the company. These duties have everything to do with the unique structure of investment companies as it relates to BDCs, however. From a traditional 1940 Act perspective, the board relies on individual service providers to manage the fund's activities on a commercial arm's-length basis. As a result, BDC directors take on more oversight responsibilities with respect to that management.
Thanks. So how do these obligations differ from the duties that you would have as a director of a typical operating company?
I think this goes to what Cynthia just said, that much of this difference has to do with the typical externally managed investment company structure and the role of investment company directors to serve as watchdogs to protect the interests of fund shareholders. Unlike a regular operating company, typical investment companies are not operated by their own employees. Instead, funds normally rely on external service providers, hence the topic of our webinar today, like the fund's investment advisor, to conduct the fund's day-to-day business, including managing the portfolio and providing administrative services. In return, these service providers receive a specified fee from the fund pursuant to various agreements. Additionally, the officers of the funds are usually affiliated with the fund's advisor or other outside service providers. Consequently, regulations pertaining to this structure are built to safeguard against the interests of fund management and shareholders of a fund not always being perfectly aligned. A fund's investment advisor has a separate interest, obviously, to maximize its own profits. In contrast, officers of an operating company are paid directly by the company, often have an equity interest in the company, and devote themselves to profit maximization to benefit both the company and themselves. While a fund's management and fund shareholders have common interests, such as seeking outstanding investment performance, there are important areas in which these interests may conflict, such as the level of management fees paid out. It's worth noting that BDCs, like other corporations, are organized pursuant to state law. The 1940 Act is not the only source of authority for management power of investment company directors. For investment companies, state law is the basic source of director authority, while the 1940 Act functions to impose an overlay of specific additional duties and responsibilities on directors.
And just one note is that actually the 40 Act does go beyond or takes you beyond the state law, because it does federalize your fiduciary duties, just to keep that in mind. So if there is a violation, there is a provision that provides that violation would also violate the 40 Act. One thing that I want to make sure that we're clear about is that effectively having overlapping boards is something that's very, very common in the mutual fund world, and has become much more common as BDCs have become parts of platforms. And so there isn't an issue in the world of funds having a board member serve on more than one board, but you do still need to take into account the conflicts that may arise as a result of that. And so it's one of those things that just to keep in mind. In addition, we're not going to spend a lot of time about independence today, but that is obviously a very significant area which is regulated by the 40 Act. And if there's a material business relationship between the company or the advisor or really kind of any of the affiliates of that advisor, that's something that has to be addressed on an annual basis and reviewed on an annual basis. And we certainly can go into more detail with you separately, but that's one of the fundamental requirements.
So back to these duties, Terry, how do they or how have they evolved over time?
Well, let's take a little trip down history lane here. The 1940 Act was established in, you'll be very surprised to hear this, 1940. And it was established to create a strong corporate governance framework for investment companies from the very beginning. Like the rest of the asset management industry, the role of independent directors has evolved and gained importance since the Act's passage. Originally, as written, the 40 Act gave its directors very few explicit duties. Primarily, they were regarding fair value and the approval of certain critical contracts and accounting services. Since 1940, Congress and the SEC have further increased the responsibilities of fund directors. For example, in 1970, Congress strengthened the role of directors when it amended the 40 Act to require that directors request and assess information necessary to evaluate the advisory contract, which is something that we're going to spend a lot more time on shortly. The SEC has also conditioned many of its rules and exemptions on particular oversight or action by fund boards, and specifically by independent directors, to address conflicts of interest, including certain affiliated transactions. More recently, the SEC has recognized the importance of independence, independent directors, and independent legal counsel to independent directors.
And wasn't there even case law that came out that the SEC had proposed a rule that required independent chairs and that type of thing, that actually the courts have cut the proposals back, but it obviously is still a focus of the staff to get as much independence into the process as possible. But and you may be guided by the fact that some of that is still on the SEC books, even though it had been overruled, and that some of those best practices are creeping into some of the SEC's guidance or regulations.
Absolutely, and you sort of see a back and forth interplay as regulatory environments change. Correspondingly, so do duties, and it goes back and forth. It does cut both ways.
So that was a good overview, but could you give us the Cliff Notes version on what specific areas a BDC director should know fall directly in his or her lap?
Absolutely. Number one is the appointment and management of the fund's investment advisor and manager, which is Section 15 of the Investment Company Act, and that's something we're focused on today. Section 17J deals with the Code of Ethics, which is really personal trading policies. Record keeping, transactions with affiliates under Section 57, which is a popular topic that keeps our phones buzzing here. Fund governance practices, compliance obligations under 38A1, fiduciary duties such as that to oversee risk, oversight of intermediaries, broker-dealers, trustees, transfer agents, accountants, et cetera, and portfolio management. Of course, there are other federal securities laws that give you further oversight obligations, reporting and disclosure obligations. Those are your Qs, your Ks, your Section 16 filings, all those sorts of things, and as well as accounting controls and procedures.
And one thing to note on the litany that Terry just went through is what we find is a lot of times people will pick up policies and procedures that don't necessarily take into account BDCs as much as they should. For example, a trading policy or code of ethics under 17J for a mutual fund that trades in and out of securities on a fairly consistent basis is not going to be appropriate necessarily for a BDC. So when you're looking at the policies, one, I guess, practical tip that we would pass on is to make sure that it really does address the functions of the BDC and how the BDC operates.
So it sounds like compliance here could be a nightmare. As a director, how do I make sure I've complied with all of my obligations?
I think the number one thing to keep in mind is that you demonstrate compliance through process. Both the SEC and courts have given credit to directors that can show via evidence that the board was actively involved with their obligations and that the board made concerted, good faith attempts to comply with those obligations. So how do you go about doing this? You actively involve with management and service providers to develop compliance plans and timetables, and you monitor and review that compliance. The good news for directors on the phone today is that courts are generally reluctant to substitute their own judgment for the judgment of business professionals and the board, provided that there's evidence that the board made a reasoned judgment.
And just to point that out a little bit more, on the when the board's looking at materials, if you're provided materials that aren't summarized or not provided in the direction that you want them to, I would suggest that a board member ask for, again, maybe a summarized or shorter version to give you kind of a lead-in to what you need to be concerned about, or red line materials, because if you ask for that from the management team, I'm pretty sure you're going to get it. So it's make sure that you're constantly thinking about what type of material will be the most helpful for you, because that's the type of thing that will basically be picked up, and that can show that you're active, that you're asking questions, and you're involved.
So with all of that, if I signed on to be a director, do I also need to now become a compliance expert? It sounds like it.
Not necessarily, Lisa. I think this goes to Cynthia's point that she just made, that a director exercises their responsibilities through using the business judgment, common sense, doing due diligence, and asking questions. Independent directors of BDCs are not expected to be compliance experts. Even so, directors should take steps to gain understanding of how the compliance regime of the particular fund operates, to assist these directors in their discussions with management, the advisor, and CCO about soundness, needs, or challenges of the BDC's compliance program. Directors do need to have a reasonable basis to rely on the advisor, management, and the CCO, and that reasoned reliance should be supported by the director's experience with these parties. In law and in practice, a board's understanding of the fund's compliance program will derive primarily from the board's interaction with the CCO. So it's important for the board to frequently consider their relationship with the CCO and the CCO's effectiveness in overseeing compliance.
And one of the ways board members can basically get more information about what they should be doing is not only accessing the CCO, but potentially accessing counsel or independent counsel that the board regularly interacts with. And certainly if there's a question that arises about whether a compliance is being done appropriate, or something else needs to be instituted, there's an exam going on, I would really suggest that you try and access one of those individuals and talk it through with them. And I do think that executive sessions are very helpful for that, because it can be more of a free and open discussion about it. And that's, I think, is helpful, especially if you're coming to this as a fairly new person and dealing with compliance in the 40 Act.
So our audience today is comprised of directors, and those directors could be on a traded BDC, a private BDC, a non-traded BDC. Does any of that make a difference with respect to what we're talking about here today?
Short answer, no. Oversight and compliance obligations remain the same based on your structure, traded, private, non-traded, whatever. Those are the same.
Great. And you've mentioned a couple times Rule 38A1. Can you give just a quick overview for those on the phone that may not have heard it? Well, I assume everyone's probably heard of Rule 38A1 before.
I hope so. As you know, 38A1 was introduced in 2003, and it's really the fund compliance program rule. The rule presents boards with new tools to oversee compliance and explicitly assigns boards responsibilities relating to the compliance function. In adopting the rule, the SEC stressed that it provides fund boards with direct access to a single person, that being the CCO, with overall compliance responsibility for the fund, who answers directly to the board. In the adopting release, the SEC noted that the rule strengthens the hand of compliance personnel by establishing a direct line of reporting to fund boards that's not controlled by management.
And what are these oversight obligations that reside under 38A1?
And this is just a summary, but it's the adoption of policies and procedures, that are intended to prevent violations of the federal securities laws. The policies and procedures have to be approved by a majority of the BDC's independent directors every year, as well as policies of external managers, administrators, transfer agents, other third-party service providers. The board must designate one person to be the CCO who reports to the board under 38A1. The CCO's designation and compensation must be approved by a majority of the independent directors, and the CCO must provide an annual written report to the board on the operation of the BDC's policies and procedures and any material compliance matters. The CCO must also meet with the independent directors separately, at least annually, in executive session, and as Cynthia mentioned, the more executive sessions may be helpful as well. There's also a prohibition on any BDC director, officer, employee, or service provider under 38A1 attempting to exert undue influence on the CCO. In an externally managed BDC, the CCO is typically employed by the external manager, like the other executive C-suite officers, but the board's obligation remains the same.
Right. So just to take that down to the very base piece of it is the CCO needs to be reviewed by the board, and the compensation needs to be reviewed and approved by the board, and that's an annual requirement. The approval of policies and procedures isn't necessarily an annual event, but it doesn't necessarily need to be a board annual event, but it definitely needs to be a CCO annual event, and a report needs to be produced. And we suggest that you actually have, if there's an update to compliance policies or again, a summary of what was changed or something along those lines, that be included in the board materials, even if you don't spend a lot of time on it at the board meeting itself. Because the 38A1 is now about 14 years old, I think, or about, and it's the SEC, the first thing that they will do when you come to an exam is that they will go to your CCO report and see if, what's included in there, how thorough is the program that you put in place. So that's really where you want to spend some time in making sure that you're comfortable that the advisor and the company are doing what they need to do under the 40 Act. I will say that there is the ability to have outsourced CCOs, and that is something that a number of BDCs do access. From the board standpoint, I would say what needs to be done there is you need to be very comfortable that they have the background experience and that you're getting the proper reports. They're more distant than somebody who's sitting in your office, and I think you have to take that into account because the staff will, if there's an issue that arises. So there's not a concern about having that occur, but it is something that the board needs to make sure that they're comfortable with, and they've done the diligence, and there's no kind of red flags out there that you haven't kind of tracked down. So I think that one more question.
The only thing to close this section out would be, with all this information in front of us as directors, should we be concerned that as a BDC director you're particularly overloaded given directors of traditional operating companies, given the obligations?
Yes and no. I mean, that's obviously always a concern, and there's more and more that's being put on directors' plates. But as a whole, the obligations require the board to be active and forward-thinking in the approach to compliance, but not necessarily always in the weeds. The compliance obligations set by the SEC do require an actively overseeing the compliance activity, managing the CCO, and familiarizing themselves with the BDC's policies and procedures, but not necessarily always being involved in the day-to-day. It's worth noting that there are several proposals to engage the SEC staff that have been floated out there in recent years to initiate dialogues regarding useful steps that could be taken to eliminate investment company board functions that aren't particularly useful, to allow boards to focus on matters where they can make the most valuable contributions, and I think that's what Cynthia touched on initially. So we'll continue to monitor those and keep you posted.
So now we're going to turn to the next section, which is I'm going to ask the questions and Lisa's going to answer them. I promise not to deviate from the questions that I proposed earlier. But anyway, so this is to discuss basically the oversight of third parties in the context of the 40 Act. So Lisa, can you describe a general framework that governs the board's role vis-a-vis the third-party service providers?
Sure. So the board's role with respect to oversight of third-party service providers is always a difficult area because it's hard to define the role. When it comes to third-party service providers, that is management's responsibility oversight, but specifically within the BDC framework, it's also an important function of the board because, as we mentioned before, most BDCs being externally managed, there are no employees in-house, so BDCs rely on advisors and third-party service providers to carry out many of the operations of the BDC. So what does that mean for the board? So the board is tasked generally with overseeing the management's operation of the fund, but specifically here, they're also tasked with overseeing the engagement and operation of third-party service providers. That sounds like a daunting task, but it's particularly important here where, given that there's no internal function, the interests of the advisor and the other service providers may conflict with the interests of the fund. So what's the recourse or the protection for the directors, because the task sounds awfully daunting? You do have the benefit of the business judgment rule, which Terry referenced generally before, and that is a measure of whether or not the board has met its fiduciary duty. Under the business judgment rule, board actions are protected from judicial inquiry so long as three things have been satisfied, and this will be an important theme for the rest of this discussion. One, that you as a director acted on an informed basis. Two, you acted in good faith. And three, you acted in the honest belief that the action taken was in the best interest of the fund. So the key here clearly is information. Without information, you cannot establish that you acted in good faith and you had an honest belief. So your job as a director is to not only actively engage, but also ensure that you're receiving the information that you believe you should be receiving.
Who are the typical third-party service providers in a BDC context?
So the list could be very long, and it varies depending on the type of BDC, the size of your BDC, your internally, externally managed. Kind of the standard ones are your custodian, your transfer agent, clearly your auditor, but the list can go on from there. Of course, a very popular one, which has almost become mandatory in BDCs, is, of course, valuation firms, third-party valuation firms. We won't spend too much time talking about third-party valuation firms specifically because it's such a hot topic. Our third webinar is going to discuss that exclusively. But it's a broad list, and the involvement with each varies depending on the relationship.
So what's the role, or what should it be for the board to approve service provider contracts?
Sure, and this one is also driven by the 1940 Act to a certain extent. So under the 1940 Act, I'm sure all the board members on the line are familiar, there's specific requirement for the board to approve the engagement of auditors and also approve the advisory contract. It also has that really arcane requirement that you have to do so in person, but that's a discussion for another time. And that's where it ends. But then I think that's when corporate law really kicks in, and it's definitely a best practice that you want your board of directors, or you as a board member want to be approving the engagement of all third-party service providers. Now, what does that mean? That doesn't mean you need to be the one that's selecting and approving. I think there's times where it's appropriate for you as a director to be involved in the selection, and that clearly would be, are you changing your auditor? And if you're changing your auditor, then you want to, given that relationship and the importance of it, you want to be involved in, hearing the presentations from the 2 or 3 audit firms that you're considering. But the 2 key components that you as a director should be focused on would be, in approving the engagement, would be, 1, what fees are you being asked to pay, or is the company being asked to pay? And does this relationship give rise to any potential conflicts of interest?
And when you're looking at the various third-party providers, one of the things that you want to, again, because in this to augment the focus on the BDCs, is you want to make sure that you've got a service provider who has dealt with the nature of what the BDC does. Illiquid investments. We've had some struggles with whether loan documents and that type of thing need to be kept in custody. Is that appropriate? How do you do it? How do you transfer the investment? So you want to make sure that you understand what their experience is as far as the BDC industry, and what's their track record. What will they tell you about who they've represented or how many they've represented, because that's crucial. It's not as though that you can't find somebody outside the BDC industry to be a third-party provider, but you want to know that they've maybe dealt with other credit funds. They're definitely in the asset management area, and those are the types of questions you want to make sure that you ask, because you can get yourself into a lot of hot water, meaning it's hard for the company to perform if they don't have a service provider that's productive. So it's very helpful if the board acts and helps management make sure that these people will actually provide the services they intend to. So what should the board look at with respect to fees, since you focused on that?
So the general standard for assessing fees is whether or not they are reasonable in light of the services being provided, and that's pretty much standard assessment of fees that you'd be most familiar with respect to what we'll call the 15C process, so how you assess whether or not an advisory fee is reasonable, and Cynthia's going to talk a little bit more about that later, so not steal your thunder there. But the other aspect here in trying to assess, then it comes into question, well, what's reasonable? And in trying to assess reasonable, boards need to have information regarding the nature and extent of the services that are going to be provided in return for the fee. So again, this is where information comes in. There needs to be that information flow. You need to understand the parameters of the engagement and what services are being provided in order to assess if the fee is too high, too low. Having the lowest fee isn't always the best indicator of having adequate service provided to the BDC.
And really, one of the things that if you're looking at fees and whether they're kind of outside the norm, or because you do want to do some benchmarking when you're looking at the fees, is the SEC is, again, concerned about the pool of assets and, more importantly, the shareholders. And so when you're thinking about how a fee is structured, is it fair to shareholders? And that's a good guidepost to use beyond what Lisa talked about.
And the only other point I'll add there is that, with respect to investment advisory fees, there's certain fee information that is disclosed publicly, and so it would be easy and advisable for management to provide you information regarding comparable fees. But there are times where there's an engagement with, say, a fund administrator or another third party where the information is not public, and at that point, if management's not able to deliver information that is helpful regarding fee comparisons, most of these service providers are well known in the industry and should be able to give you some sense if you're within the range of what other BDCs are being charged. So again, an information flow that would be on the board to question management and management to question the service provider, or if you're meeting with the service provider directly to punt those questions to them.
Beyond fees, I think you mentioned conflicts of interest. What should you be looking for there?
So this is kind of, there could be everything and anything here. There's going to be some arrangements that could present potential conflicts of interest. For example, and especially with respect to affiliated service providers, the board is going to be under an obligation to scrutinize the arrangement to ensure that it couldn't unfairly benefit the advisor or any of the other affiliated funds to the detriment of the BDC and shareholders. This is a squishy topic. It's a difficult one to get your hands around, but again, information, diligence, understanding the relationship between any related parties is going to be key.
And just, again, the fund world may be a little different than some of the other areas, including the BDCs, which is just because a complex or a number of funds that are managed by the same advisor doesn't create an issue for having that service provider basically provide services across the complex. But what you would want to do is to make sure that you know what those connections are. If there's a transfer agent who's acting for all the funds that are managed by a particular advisor, you would want to get some understanding of what what those fees were, how many funds they're involved with, what are their kind of resources, that type of thing. So you want to it's something to be aware of, but not something that creates a lot of concern. If you do have basically some third-party vendor, such as a broker-dealer or somebody who's underneath the BDC, which is or underneath the advisor complex, there are additional requirements, and you should spend more time to make sure what those connections are. But again, it's not necessarily something that would be considered inappropriate. It's just a matter of doing the diligence. So what's the ongoing role with the third-party service providers? You hire them and that's it?
Yes. Next question. No, just kidding. So, I mean, regardless of whether or not you've been involved in the selection of the service provider, you as a board member, part of your duty is to, in oversight of the management of the fund, you are subject to ongoing oversight of the quality of the services being provided by that service provider. The hard part is how do you go about doing that? You're a director, you attend meetings quarterly, telephonically, but you're not in the office day to day. You don't interact with the service provider. I always say there's three ways you can focus on accomplishing that. One is to review the materials that are produced by the service provider. An easy example is valuation firms. They're going to be producing, hopefully very long, detailed reports on a quarterly basis regarding valuations of portfolio companies they reviewed, and you're going to get a sense, because I'm sure you've probably engaged more than one service provider, and just by comparison, you can get a sense of the quality of the work that's being produced. Second thing is, if they are service providers that attend board meetings, your interaction with them would speak volumes. Are they attentive? Do they seem best in class? Are they able to answer questions? Are they well prepared? And the third, which touches on what Terry talked about earlier, is you also, as a director, get to rely on your chief compliance officer to a certain extent. So the chief compliance officer reports to the board of directors, and part of the chief compliance officer's responsibilities is to ensure compliance with federal securities laws and to evaluate the services being provided by third-party service providers. So he or she would be more your feet on the ground, and you're able to rely on the reports and information that they're sending along to you on a quarterly, if not, at a minimum, an annual basis. Do you really think it's appropriate for the service providers to attend the board meetings? Yeah, I think that just depends. It depends on the service provider. In my opinion, I think there's two types. There's service providers that I think you definitely want to see attend your board meetings, not every board meeting, but then there's service providers that I think, as I just said, you can delegate the direct oversight to the CCO, and the CCO would report to you. Kind of a general sense of who falls into those categories. So, service providers that would attend meetings are obviously your auditor, but more importantly, your third-party valuation firm. You're going to want to see them maybe annually at a minimum. Most boards will have quarterly presentations. Given the importance of the service being provided, those are the ones you're going to have constant contact with. It's also pretty common to have your insurance provider come in on an annual basis when it's time for renewal to talk to the board face-to-face about trends in the insurance industry. So I think that's appropriate. But if we're talking about your transfer agent, you don't want to lug your transfer agent into the board meeting. Same thing with a custodian. That's something that's more appropriately delegated to your CCO.
So you might want to have them come in when you initially hire them if you're forming a new fund or if you're hiring somebody new. But what I would say is it's somewhat of a rolling basis that you'd have most of them come in and talk to you at some point during the year, and that's something that you can govern through your board calendar. And what about having any kind of on-site visits?
Everybody likes a field trip.
Yeah, I mean, I feel like that's appropriate. That's where you would delegate to your CCO. Your CCO is the one that's going to be on-site, on the ground. Of course, I think unless there is an issue, but I think that's very uncommon.
I would agree. I don't think that necessarily that's where you want to be, and I think letting your CCO take that one on and report back seems to be appropriate. That's where I think you might get to a place where we might be crossing over to management, just as a insight. Anyway, so where do directors go wrong here?
So my take on it is if you're active, if you're engaged, and you've documented your activity via the minutes or via a paper trail from board meetings, you're going to be fine. The instances where directors have gotten themselves in trouble on an individual basis have been examples of egregious behavior, of extremely passive conduct. So just last year, by way of example, I mean, not to scare anybody, I think this will make everyone on the phone feel better, is that the SEC settled an enforcement case that involved 8 directors, 6 of which were independent, and the directors were found to have caused the fund to violate Rule 38A1 because they delegated too much of their responsibility with respect to the fair value of the portfolio to the third-party valuation firm without setting any parameters, without reviewing the work, just really egregious behavior. But it's important to note, the thing that I think will make you feel better is during the course of that enforcement action, the SEC emphasized that directors can be assisted by third parties in carrying out their responsibilities, but their statutory duty to determine fair value cannot be abdicated or put on automatic pilot. It requires attention and diligence. And I think for the most part in the BDC industry, given the highlight that was put on valuation, 10 to 15 years ago now, I don't think any of the BDCs that are out there would fall down on valuation.
What they're trying to make sure of is that you're not rubber stamping management's determination, and one of the ways you can make sure that doesn't come to pass is that you're asking questions as you go through the process. And that you're challenging some of the issues that may arise, and that's just being involved. So, what are the elements of good governance, and what should the board be looking for to fulfill their oversight function?
Sure. So to close out this section, if you're looking on guidance on how to fulfill your oversight function, and 5 quick tips, the Independent Directors Council, which Cynthia mentioned earlier, published 5 key principles of fund governance that would be used as a guide here as well. None of these are earth-shattering, all things that you've heard before, so again, hopefully will make you feel better. First is tone at the top. So clearly, you need a leader with a dedication to developing and supporting compliance across all aspects of the organization in order for it to be successful. Second one is compliance collaboration. You need to involve everyone. It needs to permeate the entire organization. Compliance can't just be the job of the CCO and no one else. Risk-based compliance would be third. Here, this is a recognition that there are areas that continue to evolve over time, depending on the focus of your business, the political environment. You constantly need to be on your toes, looking at all aspects of your business in order to assess where you may need to address compliance risks. Fourth is transparency and candor. Pretty self-explanatory there. Be vocal. Information flow needs to be active. And then finally, effective people and resources. And I don't think anyone in the BDC industry has a problem here, given that a CCO is mandated. There are also, huge compliance groups that have developed around the CCO, and I don't think there tends to be an issue with resources or people dedicated to the compliance function.
We're going to move to the last section, and Lisa gets to ask me questions. Or Terry gets to ask me questions. I apologize.
So, Cynthia, to put you on the hot seat now, what requirements do the 1940 Act have in place related to the approval of an investment advisor?
Right, I mean, this is an area, this contract actually has the most issues around it regarding kind of potential conflicts of interest. And what we were highlighting at the outset was unlike an operating company, you actually have two separate entities, and you can have some deviation of interest, which was what creates the conflict. So obviously the 40 Act has a lot of restrictions and requirements that go around approval of that contract. Obviously it's extraordinarily important that you have the contract in place, because otherwise the fund won't be being invested and isn't going to be successful. So it is a crucial role that the board serves here, and it's really, when you look at any of the SEC literature on this, it talks about basically providing a check on the management team, as well as basically fulfilling a watchdog function, protecting the investment company and its shareholders against overreaching, abuse, unfairness. And you'll see that over and over again if you look at anything that the SEC puts out of that. Effectively, they're looking for a gatekeeper because they are not there every day.
So, to look more at the practical nitty-gritty, when you approve an advisory contract, how long does that approval last? Is it a one-time thing? What do directors need to know?
Right. So the requirement is at the outset you have to have an approval, and that can be approved by the initial shareholders, and then you do have a period of 2 years before you have to undertake an additional approval, and that's by statute. And then once you actually go past that 2-year period, if your information is you have basically a requirement to have an annual approval. We do get some questions about in that 2-year period about whether you should do anything, and it probably should be something that's basically you take into account at the board level to make sure the services are being provided and everything still is in place and operating the way it's supposed to. But technically, from a statutory standpoint, you don't have to do that.
And what vote do you need from the board in order to pass one of these advisory contracts?
It's a majority of the independents, and obviously if you don't have independents, which we were talking about what independence means earlier, you can't have a fully authorized contract. So obviously those two pieces are very important, but it also has to be in person. And when they say in person, they really mean in person, not on a conference call, not on a video. They mean the people in the room. In some circumstances, you might be able to have just the independents or a majority of the independents in there, but you definitely need to make sure that you have the proper format, meaning you have a meeting that's called to discuss and look at all the issues that you would be undertaken in connection with the advisory agreement.
Okay, so we've talked about how you approve the contract, but obviously an important part of renewing it is how you're going to review the external manager. And is there any guidance that you can give directors on the phone about how to undertake this annual performance review of the advisor?
Well, I'll read exactly from a quote from the SEC, which is one of the ways to get insight on what they would think you should be doing. And the SEC view is the best way to ensure the funds obtain fair and reasonable fees from the external managers is through a marketplace of vigorous, independent, and diligence. Boards coupled with fully informed investors who are armed with complete, easy-to-digest disclosure about fees paid and services rendered. So that's what there's a lot of words there that go to what you should be doing, but I think that I would highlight the independent and diligent and easy to digest. And so what we do when we're looking at an advisory contract being reapproved or even initially approved, we actually have a questionnaire that we use that goes through and talks about who the advisor is, what's their regulatory structure, who are their affiliates, what are their resources, what other, who else have they operated for. And it goes into a lot of detail. It's extensive if it's done correctly. A lot of times you can rely on some of the information in your ADV form, but this would take, I would say, about you want to start doing something like this a month ahead of time, this type of a questionnaire, because the SEC has really focused on this 15C process so much more in the past couple of years that the amount of paperwork, I think, has gone up 3 or 4 times what we used to see before, and not just paperwork that is just added to the board book, but something that people are looking at. So I would say that if you're not seeing a questionnaire that goes into that kind of detail, then you might want to look at that process again. In addition, we'll talk a little bit more about the standards, but you want some information about the standards that would talk about, meaning the legal standards, as well as benchmarking. And that really is something that's very important. And then also, if you're getting paid expenses or other fees, you want to make sure that there's a comparison there.
Okay, so you've talked about this mountain of papers that the board's going to receive to evaluate the contract. What's most critical? What should they be looking for and drilling down to?
Yeah, you're really looking at the nature and the quality of the services being provided, the appropriateness of the fee, and then the structure of the advisor's compensation. And all of these factors are looked at under the lens of the Gartenberg standard, and that's the memo I was referring to. There isn't a requirement that you necessarily go to the lowest possible rate or fee. It also doesn't mean that performance is necessarily the ultimate factor here, although that's something you should be looking at. It really comes down to, and you may have heard this before, but I'm just going to read the standard again so that everybody focuses on it, is it's that an advisor fee is considered to be unreasonable if it is so disproportionately large that it bears no reasonable relationship to services rendered and could not have been a product of arm's length bargaining. So that's the standard, which is, so it actually, I would suggest it's a little bit lower than a reasonability kind of standard for a business judgment. So it gives you a little more flexibility to take into account the factors that we've already talked about. So again, I think that really what you want to focus on here is, one, what that standard is, but two, what the process that I've described, and making sure that you basically spent time and asked questions about where you are, where the industry is there been any changes, that type of thing.
Do you want to just take a second and talk about how BDCs typically accomplish this process? You know, what are the exact steps they take? How do they involve counsel? How do we help with that?
Right. So again, in a little more detail, or just from a process point, when somebody comes to you, it's the time of the year you do the 15C process. The first thing you would do would be issue this questionnaire that I mentioned to you. That's probably about 30 or 40 questions that goes basically from fund counsel or independent counsel to the advisor. The advisor gathers all the information. If there's something that's happened with the advisor, something that's changed with the advisor, all those things need to be taken into account. The performance benchmarking information needs to be pulled together. All that information should be distributed to the board, well in advance. And, if all the other materials aren't ready, you want to make sure that you're giving people at least a week, or if not more, with those materials. And then when you get to the board meeting, you don't want to just go through and run through that because you've seen it before. You want to make sure that you've got those materials explained by the advisor, as well as any questions that are answered, and then also make sure you've got the industry discussion, because for example, there's been some changes over time in the BDC fees. Some of the fees that were in place 10 or 15 years ago, people have altered them, and so there may be things you need to look at. The ones that were done 10 years ago may still be reasonable, but you want to make sure that your board members know what's out there.
Because everybody likes a good train wreck. Can you talk about where boards go wrong? What's the status of recent litigations regarding the 15C process?
Yeah, so the good news is that and this might not sound like good news, but there's been a number of excess fee cases out there under 36B, and there's been a number of them in the mutual fund world. There's only been one in the BDC world. The good news is that none of them have succeeded, based on the standard that I've highlighted for you already. But there are shareholders out there who may very well sue you, and if you go and look at any of those cases, there's a huge amount of emphasis on process. And that process is, you can have 10 pages talking about how it was done, and those are the ways that basically the boards and companies have been able to defend themselves from these types of suits. So again, you want to make sure that you're going through, and I know sometimes it sounds like checklists, but that you're going through a process to make sure you hit all these points, so that if you ever had to defend the suit, similar to what Prospect had to do, which it was dismissed, that they could actually put forward what what they did on an annual basis, and make sure that your records support it.
You know, because we're running short on time, I thought it might be helpful if you touched on whether any recent legislative changes might impact 15C.
Yeah, in the Choice Act, there is a provision that potentially could affect this 36B litigation. It would actually lower the standard from a preponderance of evidence to clear and convincing standard. The point is that it would make it harder for plaintiffs to come against boards. We don't know what's going to happen with the Choice Act or what pieces of the Choice Act, but just to let you know, and that's one of the things that you should be hearing from your counsel or board counsel, that what's happening in this area and how it impacts what you're doing.
And finally, Cynthia, are there any other considerations, any other things to keep in mind?
So I think I mentioned a little in passing earlier, just allocations of expenses. The staff has been working in this area for quite a while, mostly in the private equity area, looking at how you're allocating amongst your funds. So at this point, we would suggest that you present at your board meetings some information about how those expenses are being allocated, and it's something that we think that actually at this point it really is something you want to do on a quarterly basis, and walk through those and make sure everybody understands it. So I think that we're coming to the end of our call today. If we have questions, we have a few more minutes and we'll stay on for a minute or so. Terry, do you want to read any of the questions?
Sure. With regard to compliance and processes that demonstrate intent, what are some of the best practice resources, and how do you monitor the evolution of thinking? So really, what are we talking about when we document that the board has complied with the process?
I think what you're asking is your board minutes, and your board books are what you need to go to, and those are really the only records that you want to think that you're relying on. You don't want, for example, you want to stay away from notes and that type of thing. It's just your board materials. So I think we're, unfortunately, I think we went to the end. If you want to reach out to us individually, we'll try and answer questions that you've got. But we thank you for joining us. We will have another session later in the summer, and we'll get you with the date. But we very appreciate you joining us today, and we'll talk to you soon. Have a great day.
Thank you, ladies and gentlemen. This does conclude today's teleconference. You may disconnect your lines at this time, and thank you for your participation.